Hi, I'm Delegate Sia Price. I represent the 95th District. And as you know, we've been working on making sure that we can help prevent eviction across the Commonwealth. And so, especially during the pandemic, we were able to get some protections in place. But unfortunately, some of those are ending, but there are still some protections that will be in place. So, in order to dive into that so that you know your rights and what is there as a tool for you, I've invited some of my friends to come speak. We have Christy Mara and Laura Dobbs with the Virginia Poverty Law Center, and I'm going to turn it over to them.
Thank you so much for having us, Delegate Price. As the delegate mentioned, there are some protections that are currently in place, but a few things are going to be changing in the next few months. And we really hope that people are able to keep on top of things and are acting quickly to make sure that they get the rent relief they need in order to stay safely housed. So back during one of the special sessions, the legislature passed protections that require landlords to follow additional steps before they can evict a tenant. This is in addition to the regular court process that a landlord must follow before they can remove a tenant for non-payment of rent. So now through May 15th, here are the steps that the landlord has to take. First, they have to give a written pay or quit notice. This is a notice to the tenant that says how much money they owe, including any late fees, um, other damages that might be assessed. And it also has to include information about the Virginia Rent Relief Program and how to reach 211 Virginia to find other information on assistance in addition to the rent relief program that might be available. And it has to give the tenant 14 days to either pay or leave the property. That's why it's called a pay or quit notice. It has to give tenants that option. And secondly, the landlord has to apply for rent relief on behalf of the tenant within 14 days of sending that notice. Now, there are some exceptions to that. The landlord does not have to apply if either the tenant pays in full, meaning they catch up on everything they owe, therefore no need to apply for assistance, or if the tenant enters into a payment plan with that landlord, which we'll go over in just a few slides, or if the tenant tells the landlord that they've already applied themselves. And once they do that, the landlord needs to cooperate with that tenant in making sure that rent relief application gets complete, because it requires the landlord to submit some paperwork and the tenant to submit some paperwork to get that application finished. Now, the landlord can move forward with the eviction if the rent relief application is denied for one of a few different reasons. The first is if the tenant refused to apply for rent relief and refused to cooperate with the landlord in applying for rent relief. Now, what does it mean to refuse to apply or refuse to cooperate? It's not a matter of, if the landlord sends you a piece of paper in the mail and you dismissed it, that's not cooperating. That's bad communication from the landlord. But if you are being obstinate, not wanting to turn over key information to get that application complete, then the landlord could go to a judge and say, hey, they're not cooperating. And the judge can allow that landlord to move forward with the eviction. The second reason that a landlord can move forward with the eviction is if that application is not approved within 45 days. And that 45-day clock does not start until there's a complete application. Just because an application has been started, if it's not, doesn't have all those pieces of paperwork, such as the updated lease or the ledger, or the landlord's W-9, so that they get that check sent directly to them, the application isn't considered complete. So that 45-day clock will start as soon as that application is complete. And if within those 45 days, the landlord doesn't receive the money or doesn't get that application approved, then they can move forward with the eviction. Now, if it is a subsequent application, meaning that the tenant already received some rent relief from the rental assistance program and they're going back for some additional funds, then that repeat application, they have 14 days from a complete application. And if it's not approved within those 14 days, the landlord can move forward with the next steps in the eviction. And the third reason is if that application is denied because the tenant isn't eligible for rent relief. This could be because the tenant has already received the max amount of assistance that they're eligible for, or perhaps if they're over income for assistance. There could be a few different reasons why. However, most tenants who are applying for rent relief are going to qualify. And the last reason, which Christy will go into a little bit more, is if the rent relief program has run out of money. So that takes us to another factor that was a separate law that Delegate Price carried, and add some additional protections and options for tenants. And this is one that expires on July 1st of this year. Larger landlords must offer tenants a payment plan to help them catch up on rent. And when I'm talking about larger landlords, these are landlords who own more than 4 properties or 10% interest in more than 4 properties. If you're unsure if that applies to your landlord, I would still request, if they did not offer you one, request it yourself, and they should be defending whether or not it applies to them. But this is a really great option to help you catch up on rent, particularly if there's only a small amount of money owed. Now, when they send that written pay or quit notice is when they have to offer the payment plan. And so the tenant has 14 days to either pay the full amount or enter into this payment plan. And that payment plan has to be structured in a particular way. It has to allow the tenant to pay what they owe in equal monthly installments over a 6-month period. Now, if you have fewer than 6 months left on your lease, say you only have 4 months left before your lease expires, then they only have to offer you however many months are left on your lease. So in that situation, they'd only have to offer you a payment plan in 4 monthly installments. And as long as you've got on this payment plan, you're making your on-time payments, the landlord cannot charge additional late fees during that payment plan period. However, if you're on this payment plan and you miss a payment, the landlord could move forward with the eviction, but they do have to give you that new pay or quit notice, new 14-day notice before they can move forward with the eviction. This is just to let you know, hey, you missed a payment. Here's how much you owe based on like what you missed for current month's rent and previous back rent that you might owe, and give you an opportunity to pay that off. Now, landlords only have to let you do this option for a payment plan once per lease term. That doesn't mean that you can't request the landlord to offer you another payment plan. And even after this protection ends, I highly recommend those who have fallen behind on rent to at least request the landlord to enter into a payment plan. After starting July 1, they won't be required to do so, but it's still best practice to see if they'll be willing to work with you to try to catch up on that rent, particularly if you're also going to be applying for other financial assistance out there to help you make these installments on the payment plan. So the big news is that the Gov2Go portal, which is where the state Virginia rent relief program is administered through, it will be closing to new applications May 15th at 11, it should be 59 p.m. That means that if you haven't already gotten in your application for rental assistance, you need to get on that right away. They will be prioritizing applications where households either have an income of less than 50% of the area median income, or those where someone in the household has not been employed in the 90-day period before you submit that application. Now, if you already submitted your application before April 21st and you're not in that criteria, you're fine. They'll be serving on everyone, but after April 21st, so now they're prioritizing those who are lower income or have had job loss in the previous 90 days. So don't sit around and wait until the last second. The sooner you can get it in, the easier it will be to troubleshoot any issues with that application. And there are multiple ways to apply. You can either call the phone number here at 833-736-8735, or you can apply online. I just have a bit.ly here to make it easier to access. You could also just Google, Virginia Rent Relief Program, and it should take you directly to the portal to apply. Now, if you've already submitted an application, but you haven't gotten approval, you're waiting to hear back, there is a support email. You can email to get a status update on your application. You could also call the phone number listed on the screen to talk to someone live to get an update. And so what does this mean after May 16th? I'll turn it over to Christy to talk about that.
Thanks, Laura. And I just want to emphasize again what Laura said about applying now for the rent relief from the state through that Gov2Go portal. I think there's a lot of misinformation floating around out there about the portal possibly being closed already. That is not the case. So please do take advantage of the fact that they're still accepting new applications until May 15th at 11:59 and get that application in if you believe you're eligible, which most people are if you're having a hard time paying rent. There are a number of protections that will remain in effect until the end of June. And they may be things that you'll have to remind the landlord about, because I think so many, or I worry that so many landlords have been so focused on the rent relief that they may believe that once that portal is closed and the money is used up, these other protections also are automatically expiring, and that is not the case. So here are the things that are in effect until July 1st. First of all, the landlords must still serve a written notice on any tenant who falls behind on their rent payment. That includes, and this is the pay or quit notice that Laura has been talking about. That pay or quit notice beginning May 16th and through July 1st must include the following things. First of all, it has to include an accurate amount of the rent. It has to be the exact amount that you owe. And that would include late fees. If in fact, look in your lease. Does the lease say anything about late fees? If not, the landlord is not allowed to charge you late fees. Even if the lease does talk about late fees, if those late fees equal more than 10% of the amount you owe, the landlord is charging you too much. What do you do in the event that the landlord is charging you too much, either because they have put excess late fees on the notice or because they've added some other odd amounts to the notice? That's when you should certainly call our eviction legal helpline or get in touch with your local legal aid. Because under law, it's very important for that notice to state the proper amount so that you know what you have to pay in order to avoid being taken to court. That is always true. The fact that it has to state the proper amount is going to be true after July 1st also. But the thing that will no longer be true beginning on July 1st is that the notice has to state that there is rental assistance available. It has to give you the information not only for the Virginia Rent Relief Program, but also on how to reach Virginia 211. Virginia 211 is a service that can connect you to rental assistance programs in your local area. And that is going to be more and more important as we get beyond that May 15th deadline. Because even though the landlord has to tell you about the rent relief program at the state level, we know they're not taking new applications. So getting the information about your local programs will be critical. I would urge you actually to call Virginia 211 after you finish listening to this today to find out ahead of time what agencies or nonprofits in your area have cash assistance to give out to help you with your rent. Then there are two other things that will be ending July 1st, unfortunately. Laura talked about one of them already, and that is the fact that landlords who have more than 4 rental units must, until July 1st, offer you a payment plan. As Laura said, they only have to do that once every lease term. So if you've already, at some point during the lease term you're in now, during the lease you're in now, had a payment plan with the landlord, you're no longer entitled to get a second one. However, you can always ask. If you have never entered into a payment plan because you were able to get rental assistance through the state program, now is probably going to be the time when you might need to do so, since the portal for the rental applications is closing May 15th. And the landlord, if it's a larger landlord, must honor your request for a payment plan up until July 1st. And finally, and this is so important, until July 1st, landlords must continue to give tenants who haven't paid their rent by the deadline 14 more days to pay rent before they can bring action in court against you. Beginning July 1st, that 14-day period becomes a 5-day period. So it's just important to know that distinction. Yeah, here are the things that change on July 1st. As I just said, the pay or quit notice goes back to a 5-day period. The big thing, of course, in addition to that, is that landlords will no longer have to give tenants information about how to apply for rent relief in those notices. I think that, as we said, technically, the landlord will be required to provide information about the rent relief program until July 1st. There may be some judges who question that. So again, if you have received a pay or quit notice or receive one at any time, please call our eviction legal helpline or your local legal aid. But we know that after July 1st, none of that language regarding how to apply for rental assistance is required to be in the notice. And similarly, beginning July 1st, those larger landlords will no longer have to offer a payment plan. Laura's noted on here an important point, which is that source of funds protections apply to landlords who have more than 4 rental units. What does that mean? Well, that means that if your landlord has said to you, I don't take government money, I'm not going to take your rental assistance payment from the state or from the county, you have to come up with the money yourself. That can violate our fair housing law, because under the fair housing law, a landlord can't pick and choose which type of money he'll receive as payment for the rent. He can't treat a tenant differently simply because they're using rental assistance or a housing choice voucher or Social Security to pay their rent. It's a really important thing to keep in mind. There have not been a lot of cases brought so far under this source of funds protection, simply because it went into effect after the pandemic started. And so there were obviously different priorities given the temporary restrictions on evictions. But now it's going to be something that I think we'll see litigated more, we'll see more cases about it. So if you think your landlord is treating you differently because you're using rental assistance or a voucher or Social Security or anything like that, please do get in touch with your local legal aid or with us at the Poverty Law Center.
And a quick note about that, last week we did a training about the Fair Housing Act and went some detail about how the source of funds protections work. So if you want to learn more, we should be having a video going up on the BPLC YouTube page soon.
And there
so go check that out.
Yeah, thank you, Laura, for mentioning that. There's a lot more to the Fair Housing Act than just this source of funds protection. So by all means, please do try to find time to watch that video. One of the protections that was expanded and improved during the pandemic is still in place. It is more or less a permanent new protection, and that is the expansion of something that we call the right of redemption. What does that mean? Well, redemption is the tenant's right to pay everything that they owe the landlord and have an eviction canceled. What is everything the tenant owes? Well, obviously, it's the past due rent. It's late fees, as long as those late fees are authorized by the lease, they're stated in the lease and the tenant agreed to them. And then any court costs that the landlord paid, he can recover, he can get the tenant to pay back. So those must be paid in order to use this right of redemption. And finally, if the lease says that the tenant is going to pay the landlord's attorney's fees, those also have to be paid in order for the tenant to use this right. But the tenant can now use this right up until 48 hours before the sheriff comes to evict. So there are a couple of different ways to use the right of redemption. You can pay everything that you owe at that first court date, which is called the return date. And in that case, the case should be dismissed by the judge. It should be over. If you don't have the money by that point, or if you think that you have a defense and then it turns out the judge rules against you and you can get the money before the sheriff comes, you can still pay everything that you owe at least 48 hours before the sheriff is due to come. You will get notice of when the sheriff is coming 72 hours before the sheriff comes. So that's not a lot of time. If you're going to try to use this right of redemption after the court rules against you, you should start trying to gather the money immediately, because the sheriff can come as soon as 13 days after that court, after the judge rules against you. Now, if you're not sure how much you owe and you're getting ready to pay, you should by all means call the landlord and ask the landlord how much the total is that you owe. They are obligated by law to give you that amount. They can't say, oh, I don't know, or, oh, you need to figure it out. That would be a violation of their responsibilities under this law. And finally, if you pay everything you owe before that 48-hour period and you get evicted anyway, that could be considered an unlawful eviction under Virginia law, in which case you could sue the landlord and potentially get 4 months rent as the award that you would get from the court if you win. And that can be $5,000 or more. So it's important to know these redemption rights. One other thing that I don't think is on this PowerPoint presentation is that there's something called a redemption tender. Most people don't know about it, and I don't know how often it's used. A redemption tender is a written promise from a local government agency or a nonprofit organization to pay everything that you owe. So if you're going to use a redemption tender, find out from the landlord what is everything that I owe. And that may be the amount stated on the court paper, but it's probably going to be a little bit more, because by the time you get to court, you may have been in the unit for an additional 2 to 3 or 4 weeks. So you may owe another month's rent if you haven't already paid that. If you get, say, any of the local rental assistance programs to agree, yes, we're going to pay the rent for you, but we can't get you a check before your court date, they can give you something in writing on their letterhead saying, we agree to pay this amount within 10 days. And as long as they pay it within 10 days of the date of the first return date, first court date, your case will be dismissed. It's important to know that you shouldn't use that redemption tender if you want to dispute the case. If you don't think you owe the money, don't use the right of redemption tender, because once you bring that letter to the court, you are saying, I owe this money. And that means if you don't come up with the money by the next court date, which will be 10 days later, they're going to issue the landlord an order allowing him to evict you. Now this slide really relates more to application processes, and as Delegate Price knows, we are very concerned about a number of different things regarding the current application process for tenants to apply to live in a particular apartment or home. One positive thing that we can share with you that's in effect, I believe until, I know it's in effect for 7 years from the date it was passed. Thank you, there it is, June 30th, 2028, is, oops, can we go back to that? Thank you. Is that if you have something on your credit report, or you had an eviction case, an eviction judgment entered against you during the pandemic, which the law defines as between March 12th, 2020 and July 1st, 2021, that non-payment of rent on your credit report or bad reference from your landlord or eviction judgment cannot be used against you by a future landlord. In other words, if you apply this September and the only time you've ever been late on rent or been taken to court was during this period of time, March 12th, 2020 to July 1st, 2021, that's the only time you've ever not paid your rent, the landlord cannot say, I'm going to deny you because you have a non-payment of rent history. That would be a violation of this law. And if you are in that situation, please do call your local legal aid to get help with how to deal with that and how to bring an action. We have waited quite a while in this state to get funds for the Virginia Mortgage Relief Program, but they finally have been released by Treasury to, I think these go through Virginia Housing, so that as of 2 months ago, March 17th, 2022, Virginia homeowners are able to get up to, eligible Virginia homeowners are able to get up to $40,000 toward bringing their mortgage up to date. So who is eligible for this? Homeowners experiencing financial hardship due to COVID-19 after January 21st, 2020. So a different date than what we saw on the last slide. That owe or have a delinquency on their mortgage of $40,000 or less could be eligible for this money to bring them current. And this slide gives you the information about who to call to begin the process. Is there anything else you want to say about this, Laura? I know that you gathered this information.
Yeah, I will say, I know that there were some homeowners who originally had applied for assistance but were deemed ineligible because there used to be a different cap on the amount of assistance available. They now have an appeals process, so you can go back and try to get this assistance. It is a little bit weird that if you owe more than $45,000, you may have initially been deemed ineligible, and the expectation is that if you can cover anything over $45,000 and catch up, then you could get $40,000 from the state to help you catch up. If you're not sure or you need assistance applying, they do have a call center and office hours wherever they have offices for Virginia Housing. You can call the phone number on the top right of the screen to find out where the office is and schedule an appointment to get help in person. Otherwise, you can apply online at virginiamortgagerelief.com. And here are those resources, as Christy mentioned. If you're experiencing an eviction, you can call the Eviction Legal Helpline at 1-833-NO-EVICT to get assistance. Even if you might ordinarily not be eligible for legal aid, you can get assistance through the Eviction Legal Helpline. they do prioritize people who already have an eviction filed against them. You can also visit housing.vplc.org for other resources, whether it's about evictions or other housing issues that you may be experiencing.
Delegate Price, did we go over everything you were hoping we would go over, or are there a few other things you'd like us to talk about?
No, I think that was my main concern. I wanted, folks to know that that May 15th deadline is approaching, because I know that Tempest has gotten calls with inquiries, because we were talking, all four of us have been working on this since the rent relief started. And so I know a lot of people heard it and then maybe thought that they had a little bit more time, but now we are at the end of the road. We need people to make sure that they get their applications and information in before May 15th, right? Let's aim for before May 15th,
That's right.
but definitely by May 15th. And so I wanted to thank you all, and just also, these ladies and Legal Aid, Virginia Poverty Law Center and Legal Aid are literally on the front lines of helping in the courtrooms, and just advocacy, and our relationship working together got us to some of those protections legislatively in the budget, the bills I carried, the bills other legislators carried. And so I want to thank you for your partnership and for what you do to make Virginia really a better place to live. And we'll also put some of these resources on our website. We have our contact information. You can reach out to the office. Tempest is always available to help, but we just want to make sure that everybody has access to the resources they need, the answers they need. And if you have any questions, we'll have Virginia Poverty Law Center's contact information, Legal Aid's contact information, and our office contact information as well. I just want to say thank you. Thank you for helping us get it out there.
Thank you, Delegate Price. We so appreciate this partnership. It's invaluable to everybody, all of the tenants.
And we're going to keep fighting. I know that some folks have been following the bills that we worked on together last session with the devastating veto of House Bill 802. But I know these ladies personally, and I know we are not done fighting. And so we'll keep working, for safe and fair and affordable housing here in the Commonwealth. So thank you. We look forward to hearing from you with your questions. Take care.
Thank you. Bye.
Thank you.